You aren't just watching a routine legal filing, you are watching a high-stakes tactical error that might just strip away the one thing the Trumps value most, their carefully guarded privacy. For years, the strategy has been to delay, deflect, and dodge. But in the Southern District of New York, a new filing on behalf of Melania Trump suggests that the walls are not just closing in, they are being reinforced by her own legal team. On January 5, 2026, a letter was sent to the Honorable Mary Kay Viscochil, a Trump appointee, regarding the case of Michael Wolff versus Melania Trump. The core of the argument? Melania claims she was never properly served with the lawsuit, and that New York has no business holding her accountable because, as her lawyers claim, she simply doesn't live there in a legal sense. But here is where the catastrophic backfire begins. By claiming she doesn't reside in New York to avoid a lawsuit, Melania has inadvertently walked into the discovery trap. In federal court, when you challenge jurisdiction, the judge doesn't just take your word for it. They allow what is called jurisdictional discovery. This means Melania Trump, a woman who has spent years perfecting the art of being invisible, may now be legally compelled to sit in a chair, under oath, and answer the most intrusive questions imaginable. Where do you sleep? How many days a year do you spend at Trump Tower versus Mar-a-Lago? Who do you live with? What are your daily habits on Fifth Avenue? These aren't just gossip points. They are now legal requirements to prove she isn't a New Yorker. Her lawyers, including Alejandro Brito and the corporate giants at DLA Piper, are trying to shield her from a defamation claim by Michael Wolff involving Jeffrey Epstein's alleged comments. However, in their zeal to dismiss the case, they may have handed the opposition a golden ticket to peer behind the curtain of the Trump marriage and their private residency. The irony is thick. To prove she is a Floridian, she must expose the minutiae of her life in New York. As we dive into the details of this filing, you'll see why even a Trump-appointed judge might not be able to save her from the very door she just opened. Federal judges have very little patience for high-profile defendants who treat the legal system like a game of hide-and-seek, and even a Trump-appointed judge won't tolerate a service dodger for long. In this segment, we examine the core of Melania Trump's panicked legal strategy, the claim that she was never properly served because the lawsuit was handed to a doorman at Trump Tower. While this may seem like a clever procedural delay, it is actually a dangerous gamble that could force Melania to surrender her most prized asset, her privacy. The heart of the defense filing, signed by Karen Schechtman and Alejandro Brito, argues that the court lacks personal jurisdiction over Melania Trump. They are positioning the former First Lady as a stranger to New York, claiming the case belongs in Florida because that is her true home. However, to understand why this is a catastrophic backfire, we need to look at the two types of jurisdiction, general and specific. General jurisdiction exists where you are at home, your domicile, and you can be sued there for anything. Specific jurisdiction applies if you committed a specific act, like defamation or a breach of contract, within that state. Neutral legal perspective. Challenging service of process is often a standard delay and pray tactic. However, in federal court, dodging service can result in the defendant being hit with the plaintiff's legal fees and costs for having to track them down. Melania's lawyers are attempting to remove the case from New York State Court to federal court, and then ultimately transfer it to the Southern District of Florida. They are clearly hoping for a friendly platform and a random draw that might land them in front of Judge Aileen Cannon in West Palm Beach. But there is a massive price tag for this maneuver. To prove she doesn't live in New York, Melania has opened herself up to jurisdictional discovery. This means Michael Wolff's lawyers can demand that she sit in a chair under oath for a grueling deposition. They will grill her on the minutiae of her daily life. How many lady lunches does she have on Fifth Avenue? How much time does she spend at Trump Tower across from Bergdorf Goodman? Does she actually live with Donald Trump, or is Mar-a-Lago just a secondary residence for parties? By trying to avoid a lawsuit about what Michael Wolff heard from Jeffrey Epstein, she has inadvertently handed Wolff the power to legally pry into her most private living arrangements. When you are embroiled in a billion-dollar defamation fight against a seasoned journalist, the legal team you field is as much a statement as the evidence you present. And Melania Trump's choice of counsel suggests a strategy that is as unconventional as it is risky. In this segment, we peel back the curtain on the attorneys Melania has recruited for this specific battle and why their background might be the Achilles heel in her pursuit of Michael Wolff. Leading the charge is Alejandro Brito, often described as Donald Trump's lawyer of last resort for defamation cases in Florida. But the real surprise lies in the supporting cast. DLA Piper, a massive corporate law firm primarily known for handling the securities and corporate work for Trump's Truth Social. They've also brought in Karen Schechtman, who, according to her own professional bio, focuses on securities litigation rather than the complexities of the First Amendment. Her most recent major publication was reportedly about cannabis and securities litigation, a far cry from the nuanced world of media law and libel. Neutral legal perspective. In high-profile defamation cases, defendants usually seek out specialists in First Amendment law who understand the high bar for actual malice. Bringing in a securities team suggests Melania may be treating this more as a corporate asset protection move than a standard libel fight. This unconventional team is now facing off against Michael Wolff, who executed a brilliant preemptive strike. Rather than waiting for Melania to sue him, Wolff ran to court in New York to file a declaratory judgment action. He is asking the court to declare that his reporting, which allegedly involves information about Melania Trump and Jeffrey Epstein, is not defamatory and is protected by New York's robust anti-SLAPP law. Anti-SLAPP laws are designed to prevent powerful individuals from using massive lawsuits to chill free speech or silence critics. The filing recently landed on the docket of Judge Mary Kay Weisskottil, a Trump appointee in the Southern District of New York. While some might assume a Trump appointee would be inherently sympathetic, federal judges are notoriously protective of their courtroom's integrity. If Melania's team, led by securities lawyers, fails to navigate the specific hurdles of New York's defamation statutes, they risk having the case dismissed before it even begins. By threatening a billion-dollar claim, Melania may have inadvertently triggered the very legal protections that Wolff is now using to cement his reporting into the public record. Imagine being one of the most private women in the world, having spent years carefully curated behind gold-plated doors, only to be forced by your own legal strategy to answer under oath exactly what goes on inside your home. In this fourth segment, we explore the discovery trap that Melania Trump's team has inadvertently set for her, a trap that could turn her residency dispute into a public autopsy of her private life. By filing a motion to dismiss based on a lack of personal jurisdiction, Melania's lawyers didn't just ask the judge to drop the case, they invited a process known as jurisdictional discovery. This is a specific phase where the plaintiff, Michael Wolff, is granted the legal authority to verify whether Melania's claims of living exclusively in Florida are actually true. For a typical defendant, this is a chore. For Melania Trump, it is a catastrophic backfire. Neutral legal perspective. Jurisdictional discovery is a standard procedural tool used to prevent defendants from simply claiming they don't live in a state to avoid being sued there. If a defendant makes their location a central part of their defense, the court allows the other side to smoke out the truth through depositions and document requests. What does this mean in practical terms? Michael Wolff's lawyers can now demand that Melania Trump sit for a deposition, a recorded under-oath interrogation that could last for hours. They won't just ask about her driver's license or tax returns. They will ask about her lady lunches at the corner of 59th and 57th Street. They will ask how many nights a week she actually spends at Trump Tower versus Mar-a-Lago. They will ask about her shopping sprees at Bergdorf Goodman and her time spent with her son, Barron, who is reportedly living down Fifth Avenue at NYU. The most sensitive area, however, involves her relationship with Donald Trump. While a judge may prevent lawyers from asking what bedroom she sleeps in, they can absolutely ask about the nature of her residence with him. Does she live with him in Florida as a primary occupant, or is she merely a guest at Mar-a-Lago during parties? Melania's attempt to dodge Michael Wolff's reporting on Jeffrey Epstein has now legally empowered Wolff to investigate the very things the public has been curious about for a decade. By arguing she is a stranger to New York, she has ensured that her life in New York will be meticulously documented in a federal court record. The golden rule of federal litigation is simple. You can hide, but you'll eventually have to pay for the privilege of being found. In this fifth segment, we break down the mechanics of Melania Trump's attempt to dodge the process servers and why this specific panicked tactic often results in a humiliating financial penalty from the court. Melania's legal team has made insufficient service of process their lead argument in their letter to Judge Weisskottil. They argue that because the doorman at Trump Tower was the one who received the papers, Melania herself was never officially notified. But as George Williams points out, federal judges, even those appointed by Donald Trump, are not fond of defendants who treat the legal system like a game of hide and seek. In federal court, everyone needs to put on their big boy pants, because dodging a professional process server is not just difficult, it's expensive. Neutral legal perspective. Under the federal rules of civil procedure, there are multiple ways to smoke out a defendant who is evading service. If a defendant refuses to sign a waiver of service, the judge can order that defendant to pay all the costs and legal fees associated with the plaintiff having to find and serve them by other means. Melania has reportedly been hiding out at Mar-a-Lago, the White House, or her penthouse at Trump Tower since the case was originally filed back in October. However, the court has tools to bypass these physical barriers. Judges can authorize constructive service or substitute service, which effectively means that if the court is satisfied you are intentionally dodging, they will deem you served, regardless of whether you personally touch the papers. By focusing so heavily on the doorman and the technicality of service, Melania's team is essentially telling the judge that she is aware of the lawsuit but is choosing to ignore it. This is a strategic blunder because it paints Melania as a service dodger in the eyes of the person who will eventually decide the fate of the case. Instead of looking like a victim of a meritless claim, she risks looking like a defendant with something to hide, all while potentially racking up a massive bill for Michael Wolff's legal fees before the actual defamation arguments even begin. In the world of federal litigation, a judge's political pedigree often matters far less than the integrity of their own courtroom, and for Melania Trump, that distinction could be the line between a swift dismissal and a grueling public interrogation under oath. In this sixth segment, we deconstruct the hope Melania's legal team has placed in Judge Mary Kay Weiskachil and explain why the reputation of the Southern District of New York, SDNY, often creates a catastrophic backfire for defendants expecting political favoritism. On December 30, 2025, the case of Wolff v. Trump, case number 125 CV 10752, was officially assigned to Judge Mary Kay Weiskachil. While Melania's team, led by securities litigator Karen Schechtman, may view this as a victory because Weiskachil is a Trump appointee, the reality of the SDNY is far more complex. The SDNY is known as the Mother Court, an elite venue where judges prize their reputation for impartiality and technical mastery above all else. Federal judges here are notoriously protective of their court's dignity and are historically allergic to defendants who treat legal procedures like a game of hide and seek. Neutral legal perspective. Each judge's individual rules and practices are the absolute law in their courtroom. Judge Weiskachil, like many in the SDNY, requires a pre-motion conference before any motion to dismiss can even be filed. This is not a mere formality, it is a pressure test where the judge can grill attorneys on the merits of their arguments before they even get to file a full brief. If Melania's lawyers cannot provide ironclad evidence that she is a stranger to New York, despite her son Barron attending NYU and her own reported shopping sprees at Bergdorf Goodman across from Trump Tower, Judge Weiskachil may view the jurisdictional challenge as an act of bad faith. Furthermore, Michael Wolff has anchored his case in New York's powerful Anti-SLAPP statute, designed to penalize those who use massive lawsuits to chill free speech. By betting on a friendly judge, Melania's team has inadvertently walked into a trap. If Judge Weiskachil follows the letter of the law and grants jurisdictional discovery, she will be the one handing Michael Wolff the subpoena power he needs to investigate the former First Lady's private life. In the SDNY, the only thing more certain than the law is that an appointee will not risk their professional legacy to shield a defendant from a simple, under-oath conversation about where they actually live. In the high-stakes world of political litigation, sometimes the most important decision isn't what the law says, but whose name is on the bench, and Melania Trump's team is betting everything on a judicial lottery in the Sunshine State. In this seventh segment, we analyze the final fallback position in Melania's panicked filing, the demand to transfer the entire case from the skyscrapers of New York to the Southern District of Florida. This is more than a change of scenery. It is a calculated attempt to find a friendly platform where the rules of the game might be played differently. The legal mechanism at play here is a motion to transfer venue. Melania's lawyers argue that because she is a resident of Palm Beach, it is inconvenient and improper for a New York court to preside over a case involving her private life and her alleged relationship with figures like Jeffrey Epstein. By attempting to move the case, her team is hoping to escape the Mother Court of Manhattan and land in a jurisdiction they perceive as more sympathetic to the Trump family legacy. Neutral legal perspective. Venue shopping is a common strategy in high-profile cases. Under federal law, a case can be transferred for the convenience of parties and witnesses in the interest of justice. However, plaintiffs like Michael Wolff usually get to choose their forum unless the defendant can prove that the current venue is overwhelmingly burdensome. But here is where the catastrophic backfire takes a mathematical turn. If the case is transferred to the Southern District of Florida, it doesn't automatically go to a judge of Melania's choosing. It goes into what lawyers call the random wheel. In the West Palm Beach Division, there are only a handful of judges who could take the case. The name Melania's team is undoubtedly praying for is Judge Aileen Cannon, the same judge who presided over Donald Trump's classified documents case and has been criticized by some for her favorable rulings toward the former president. However, the wheel is unpredictable. In the same division, you have Judge Middlebrooks and Judge Rosenberg. Judge Middlebrooks, in particular, has a history of ruling against Donald Trump in previous litigation, even hitting him with massive sanctions for filing what the judge deemed frivolous lawsuits. By forcing a transfer to Florida, Melania is essentially walking into a casino. She has a 50-50 shot of landing in front of a judge who might be even more skeptical of her service-dodging and jurisdictional games than the judge she is currently trying to flee in New York. The Florida lottery is a desperate gamble, and if the ball lands on the wrong number, the very court she fought to reach could become the venue for her legal undoing. The ultimate tragedy of this legal strategy isn't just that Melania Trump might lose a lawsuit, it's that in her attempt to remain untouchable, she has potentially dismantled the very shield of privacy that defined her public life. In this final segment, we reach the endgame of the Wolff versus Trump jurisdictional battle and ask the hardest question of all. What happens to the American presidency when its most private figures are forced into the light by their own legal blunders? As we have seen through these 8 chapters, the panicked filing was never just about a doorman at Trump Tower or a move to Florida. It was a high-stakes stress test of the American legal system's ability to treat a former First Family like any other citizen. By challenging the court's authority, Melania's team, led by Alejandro Brito and corporate giants at DLA Piper, didn't find an exit ramp. They found a microscope. The discovery trap is now set, and the bait is the very secrecy that Melania has spent decades cultivating. Neutral institutional analysis. The resolution of this case will set a permanent precedent. If a judge like Mary Kay Weiskachil rules that jurisdictional discovery must proceed, it sends a clear message to all public figures. The courtroom is not a place for hide and seek. Conversely, if the case is transferred to Florida, it will test the random lottery of the judicial wheel, potentially landing in the hands of a judge like Middlebrooks, who has little patience for frivolous maneuvers. The real catastrophic backfire isn't just the legal fees or the inconvenience of a deposition. It is the fact that Michael Wolff, a man the Trumps wanted to silence with a billion-dollar threat, has now been granted the legal subpoena power to document the inner workings of the Trump marriage, their residency habits, and their connections to figures like Jeffrey Epstein, all under the penalty of perjury. What began as an attempt to save face has ended with the potential for a complete unmasking. Tonight, we aren't just watching a drama about one woman. We are watching the slow, grinding machinery of the law remind us that power, regardless of its status, is eventually subject to the same rules as everyone else. The question is no longer whether Melania survives this lawsuit, but whether the aura of mystery she built can survive the deposition chair. If you are tired of news coverage that only screams chaos without explaining how the system is actually working, subscribe to George Williams. Tell me in the comments, which part of this legal trap do you think is the most damaging for the Trump legacy? The loss of privacy, the exposure of their residency, or the fact that their own lawyers led them into this?